Welcome to the AskJunior Daily Judgment Podcast. I'm Priya Sharma, and joining me today is Arjun Mehta.
Hello, everyone. We're excited to dive into today's important judgment. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now let's get started with today's case, which is a significant one concerning Section 6A of the Citizenship Act 1955.
Absolutely, Priya. Today we're discussing a landmark judgment that addresses the constitutionality of Section 6A of the Citizenship Act 1955. This case has far-reaching implications for the state of Assam and the broader issue of citizenship in India.
That's correct, Arjun. The case before us is titled In Re Section 6A of the Citizenship Act 1955, and it's a consolidation of several writ petitions challenging the constitutional validity of Section 6A. To give our listeners some context, Section 6A was introduced in 1985 as a result of the Assam Accord, which was a political settlement aimed at addressing the issue of illegal immigrants in Assam.
Exactly. The Assam Accord was signed on August 15, 1985, after years of agitation and unrest in Assam over the issue of illegal immigration from Bangladesh. The accord set different cutoff dates for granting citizenship to immigrants who entered Assam from Bangladesh.
That's right, Arjun. Section 6A essentially created three categories of immigrants. One, those who came to Assam before January 1, 1966 were to be granted citizenship. Two, those who came between January 1, 1966 and March 24, 1971 were to be detected, their names deleted from electoral rolls, and then granted citizenship after a 10-year period. 3. Those who came on or after March 25, 1971 were to be detected and deported. This classification and the overall validity of Section 6A is what was challenged in the present case. The petitioners argued that Section 6A violates various provisions of the Constitution, including Articles 14, 21, 29, and 355.
That's correct. Now, what's interesting about this judgment is that we have two different opinions from the bench. Justice Surya Kant, writing for himself and two other judges, upheld the constitutionality of Section 6A. However, Justice J.B. Pardiwala, while agreeing on some points, ultimately concluded that Section 6A has become unconstitutional over time.
This split in opinions makes for a fascinating legal analysis. Let's start by looking at Justice Surya Kant's reasoning for upholding Section 6A. What were the key points in his judgment, Arjun?
Justice Surya Kant's judgment addressed several key issues. First, he rejected the argument that Section 6A violates the preambular notion of fraternity. He argued that the concept of fraternity in the Constitution is meant to be inclusive and cannot be applied in a restrictive manner to protect only the endogamous way of life of a specific community.
That's an important point. It seems Justice Surya Kant is emphasizing that the Constitution's idea of fraternity is about bringing people together, not keeping them apart.
Exactly. He also addressed the argument that Section 6A violates Articles 6 and 7 of the Constitution, which deal with citizenship rights for those who migrated during partition. Justice Kant held that Parliament had the competence to enact Section 6A under Article 11 of the Constitution, which gives Parliament the power to make laws regarding citizenship.
That's a crucial point. Article 11 seems to give Parliament quite broad powers when it comes to citizenship laws. Did Justice Kant address the Article 14 challenge as well?
Yes, he did. Justice Kant rejected the argument that Section 6A violates Article 14, right to equality, by treating Assam differently from other states. He held that the unique historical and political circumstances of Assam, including the Assam Accord, provided a rational basis for this differential treatment.
That's interesting. It seems the court is giving significant weight to the historical context and the political settlement that led to Section 6A. What about the other constitutional challenges?
Justice Kant also rejected challenges based on Articles 21, right to life and personal liberty, 29, protection of cultural rights, and 355, duty of the Union to protect states against external aggression and internal disturbance. He found that the petitioners failed to establish how Section 6A violated these constitutional provisions.
So, in essence, Justice Surya Kant's judgment upholds Section 6A as a valid exercise of parliamentary power, taking into account the unique circumstances of Assam and the political settlement reached through the Assam Accord.
That's correct. However, Justice J.B. Pardiwala's opinion provides a different perspective. While agreeing with Justice Kant on some points, Justice Pardiwala ultimately concluded that Section 6A has become unconstitutional over time due to what he calls temporal unreasonableness.
That's a fascinating concept. Can you explain what Justice Pardiwala means by temporal unreasonableness, Arjun?
Certainly, Priya. The concept of temporal unreasonableness, as explained by Justice Pardiwala, is based on the idea that a law which may have been reasonable and valid when enacted can become arbitrary and unconstitutional over time due to changing circumstances.
That's an interesting legal principle. How did Justice Pardiwala apply this to Section 6A?
Justice Pardiwala argued that Section 6A has become manifestly arbitrary over time for several reasons. First, he pointed out that there's no temporal limit on the applicability of Section 6A.3, which deals with immigrants who entered Assam between 1966 and 1971. This means that even today, an immigrant from that period could potentially claim citizenship under this provision.
That does seem problematic. It essentially leaves the door open indefinitely, doesn't it?
Exactly. Justice Pardiwala also criticized the mechanism prescribed under Section 6A, particularly the fact that the onus of detecting foreigners lies solely on the state. He argued that this, combined with the lack of a temporal limit, has actually incentivized illegal immigration rather than curbing it.
That's a strong critique. It suggests that the provision had the opposite effect of what was intended. Did Justice Pardiwala address the impact on Assam's demographics?
Yes, he did. Justice Pardiwala expressed concern that the open-ended nature of Section 6A has led to significant demographic changes in Assam. He cited various reports and studies suggesting that the proportion of Bengali-speaking and Muslim populations in Assam has increased rapidly between 1951 and 2001, which he attributed largely to immigration.
That's a sensitive issue. How did Justice Pardiwala balance these concerns with the humanitarian aspects of granting citizenship to long-term residents?
That's a great question, Priya. Justice Pardiwala acknowledged the humanitarian considerations behind Section 6A, but he argued that these considerations needed to be balanced against the impact on Assam's indigenous population and the state's resources. He felt that the current mechanism under Section 6A fails to strike this balance.
So what was Justice Pardiwala's ultimate conclusion?
Justice Pardiwala concluded that Section 6A has become unconstitutional due to the efflux of time. However, recognizing the potential chaos that could result from an immediate invalidation, he proposed that Section 6A be declared unconstitutional with prospective effect.
That's a nuanced approach. It seems to try to address the constitutional concerns while also avoiding immediate disruption. How does this prospective invalidation work?
Under Justice Pardiwala's proposal, those who have already been granted citizenship under Section 6A would retain their status. However, from the date of the judgment, no new citizenship claims could be made under Section 6A. All future cases of illegal immigration would be dealt with under the general laws applicable to the rest of India.
This is indeed a landmark judgment, Arjun. It raises complex questions about citizenship, immigration, and the balance between national security and humanitarian considerations. What do you think are the broader implications of this judgment?
The implications are indeed far-reaching, Priya. This judgment touches on fundamental questions of who gets to be a citizen and under what circumstances. It also highlights the tension between addressing historical injustices and dealing with contemporary realities.
Absolutely. It's worth noting that this judgment comes at a time when issues of citizenship and immigration are hotly debated, not just in India, but around the world. Do you think this judgment might influence how other countries approach similar issues?
That's an interesting point, Priya. While every country's situation is unique, I think this judgment does offer some valuable insights that could be relevant elsewhere. It highlights the need for clear, time-bound policies on immigration and citizenship, and the importance of considering long-term demographic impacts.
Indeed. It also underscores the challenges of implementing political agreements through legislation, especially when dealing with complex issues like citizenship and immigration.
Absolutely. This case is a reminder of how laws can have unintended consequences over time and the importance of periodic review and adjustment of policies, especially in sensitive areas like citizenship.
Well, Arjun, I think we've given our listeners a lot to think about today. This judgment is likely to be debated and discussed for years to come, given its potential impact on Assam and the broader implications for citizenship law in India.
You're right, Priya. And that wraps up our analysis of today's judgment. We hope you found our discussion informative and engaging.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Arjun Mehta.
And Priya Sharma signing off. Thanks for listening to the Ask Junior Daily Judgment Podcast.